everyone, I'm Heather Scott. I'm a partner at Gill Jennings Every. We're a specialist IP law firm in London, and I'm a UK and European patent attorney. Today, I'm going to be giving you a very quick introduction to patents. So, patents are intellectual property rights which are available to protect new technical innovations. For example, it might be a new physical product. Maybe it has a new construction or a new functionality to it. Maybe it's a new method of making something. Or you can also patent new processes which enable things to function in a new way, such as a control system for a manufacturing site. So often the innovation is something which solves a technical problem. And I think the best way to understand this is to look at some examples. So I've got here a couple of my favorite patents with companies that I have worked with. So this invention was made by my client Delarue, and they're the company that make all of the banknotes in the UK and indeed in many other countries around the world. And what this is an anti-counterfeiting device that you can put on a banknote to stop it being readily photocopied. So here is a Scottish banknote with the device on, and what I'm interested in is this bright green ring that's on the map of Scotland. And this prevents the banknote being photocopied because in real life, the bright ring looks very three-dimensional and it sort of moves as you tilt the banknote. But obviously in a photocopy, it will just look static. So you can easily tell that it's not a real banknote. So there, the problem being solved is how to provide a device which prevents a banknote being photocopied, which the counterfeiters haven't already been able to copy. And this is done, in this case, by using very clever ink, which comprises particles which have a color-changing effect with a magnetic core. They're placed in a magnetic field, as shown on the right here, and arranged to produce this effect before the ink dries. So that's one example. A second example is something by my client Leptosense. And here, this is a particle separation and identification device and method, which enables you to put in particles, they're spun around in a very clever electric field, and separate them out from each other and work out what they are. So it can be used for detecting drugs or DNA sequencing, could even be used possibly to identify viruses. So there, the technical problem that's being solved is how to more quickly separate particles and identify them. So those are just two examples of patents in certain fields of technology, but in practice they're available across the whole range. Now, what is a patent? A patent is a negative right, and that means that it gives the owner the right to stop other people using the invention that's defined in the patent. It doesn't actually give the patent owner themselves any rights to work the invention. It's still possible that in doing so, they might infringe an earlier patent. Nonetheless, it still protects your inventive contribution, and therefore it's very valuable. In most countries, a patent can be maintained in force for up to 20 years from its filing date. And that time span has been arrived at as a bit of a compromise between giving the owner sufficient time to recoup his investment into coming up with the invention and bringing it to life, versus the public interest in needing to make that accessible for all. Another really important point to note is that patents are highly territorial, and that means that any particular patent will only be effective in the country which has granted it. So, for example, you can't use a British patent to stop an activity taking place in the USA. You actually need to apply for a patent in every country that's of interest to you. There is also no such thing as a worldwide patent. So that's something that you see mentioned in the press sometimes, which just doesn't exist. Now, it must be said that patents aren't cheap. There is a big cost to them. So why apply? What are the benefits? Well, the first and most obvious one, of course, is to block competitors from using your technology, if you're prepared to sue them. Or more likely, if you intend to be bought by a big company that is. Also, patents themselves increase your company valuation because they are valuable assets in their own right. You can sell them, for example. Or if you're happy to allow other people to work the invention, you can also license them out and get royalty fees as a result. You can also use patents to bargain with competitors because they might well have something that you want and then you have something that they want too. Finally, they can also be used as a defensive position because the disclosure that you make in a patent application can prevent later patent applications from succeeding. That last point is also a reason why in some rare cases, you might want to weigh up whether filing a patent is actually the best thing for you, because they will be put in the public domain whether or not it's granted. For instance, the two examples I explained to you earlier were both published many years ago. So how do you apply for a patent? Well, there are several criteria which a patent application must meet in order to be granted. But probably the two most important ones are, firstly, that the invention defined in the patent application must be novel. And that means that it's got to be new, even if only in some small way, relative to all previous disclosures that have been made before the filing date. And that includes your own. Secondly, it's got to be inventive. And that means that it must not be just an obvious modification of something that's already known. So what this means in practice is that when you think you've come up with a new invention that you might want to patent, don't disclose it to anyone, any third party, in a non-confidential way before the patent application has been filed. It's really important to talk to a patent attorney early on so that the patent application can be drafted and filed before you need to disclose it. And that will ensure that you haven't destroyed the novelty of your application. And then the patent attorney will be able to advise you on whether it's likely to be considered inventive. So if you'd like to find out more information about patents or any other type of IP, you can do that by looking at our website, which is www.gje.com, or feel free to email me, heather.scott@gje.com, or connect with me on LinkedIn. Thanks very much.